question regarding cannabis consumption in public. The drafters of the MRTMA and the language of the act itself pretty clearly indicates that being caught consuming cannabis in public is a civil infraction, like a $100 fine. But we're concerned that there are some elements within the Attorney General's office that may not agree that that's the definition of this. Can you clarify for our viewers what the status is of that, or what the official designation is?
Sure. Well, as you know, there are a number of different laws out there that unfortunately are not completely in concert with each other. Of course, we have the MMMA, the MMFLA, and then MRTMA most recently. So there are aspects of them where one might differ from another, and it creates confusion. And that's why after I got into office, we created a work group to specifically talk about these issues. And we had defense attorneys, we had the Prosecuting Attorneys Association, we had the Michigan State Police, we had Andrew Brisboe from MRA, Michelle Bry was part of that committee or that work group. And then, Sato was on the work group. We had a number of different actors that we could all come together and say, okay, where are there issues where it's not entirely clear because maybe one of these laws contradicts another law, and how do we come to a space where we can all agree on what the law between all of these things really should be, and then we give that to the legislature so that they can draft a new law to make it absolutely clear. And of course, we wanted to have people at opposite ends of the spectrum so that we felt as though if we were making these recommendations, this group of all these different actors that were involved in the marijuana space, that hopefully the legislature would act upon that. I'll be honest with you, unfortunately, COVID has interfered a lot with this work group, the same way that a lot of different things that we were doing, we've had issues with because we could not all meet together. So I know it's been a few months since that group has met, but we did make a number of different proposals, and I think that that was actually one of them. David, I wonder if you could talk a little bit more about the work group, the proposals, and what's happening with all that.
Yeah, it's actually a very timely question. I know that Michelle and I were on the phone earlier today, actually, on this very topic. I think the legislature acknowledges the discrepancies between, as you mentioned, MMFLA, MMMA, and MRTMA. I think I threw an extra M in there somewhere. And they want to fix that, right? And I think that they want to fix that because of the things that Rick just talked about. There's confusion, not just among the public, amongst the business community, amongst everybody. And so if there's a way for us to bring these three statutes in alignment with one another, I think the legislature wants to do that. The work group that you talked about did draft a series of recommendations that we put forth to the legislature. I believe it was back in May. And as you mentioned, just the same way that COVID has interrupted the work group from meeting, it has also interrupted the legislature's operations as well. But it was last week that we received an email from one of the caucuses in the legislature saying that they are ready to take a deeper dive on this issue. They're trying to pull in our office and others to try and bring these three different statutes in alignment with one another. So I'm hopeful that this is something that we can see action on by the end of the year. I know folks have been waiting for it for a long time. The one thing that, again, I do feel very confident in is that our office has already done a lot of the legwork of pulling together the various stakeholders to make these recommendations. In a perfect world, the legislature would take what we give them and rubber stamp it because we've done the work and we've got the experts. We all know that's not how it goes, right? But to the extent that our office has had the opportunity to have input and a say in making those changes, the legislature has them in their hands, and I'm hoping to see something introduced here shortly.
Hey, David, I was just going to say, can we get those recommendations together and make them public? Can we at least send them to the Cannabis Caucus so they know what issues we worked on and what our recommendations were?
I would usually, if asked that question, ask you for permission to do that, Dana. And so if you're cool with it, I think I'm cool with it too.
I am. I think people should know what we're working on, obviously. And like I said, we try to have all facets. We want to have as many voices in the room as possible on this. And I have to say, there was largely agreement. I don't know, Michelle, I mean, I don't know what your thoughts are on this, but almost every one of these issues, our votes were unanimous.
Yes, Attorney General, I think there were a lot of voices in the room, and I think that was great because it was a good cross-representation of the stakeholders here. And I think what we did try to do were tackle issues that we thought we could all agree on so that we could make some significant progress rather than getting caught up in some of the differences that some of the individuals might have. And I think we did make some good progress, and I look forward to those continued discussions.
And I do want to say, so we had, like I said, we had a representative from the Michigan State Police. We had a representative, well, actually we had several representatives from the Prosecuting Attorneys Association. And I was surprised at the lack of pushback that they gave the defense attorneys that were there in terms of their interpretation. I mean, they were in agreement. And I have to be honest with you, I think from the, I don't want to speak for the Prosecuting Attorneys Association in Michigan, even though I'm on the board, and I certainly don't want to speak for the Michigan State Police. But the impression that I got was, I don't want to say they're over marijuana. That's not like the best way to phrase this, but just that they have bigger fish to fry, and that on most of the discussion that I saw was moving towards, the understanding that the voters of the state had decided that marijuana, under most circumstances, was no longer to be illegal, and they didn't want to have to deal with it. Basically, they weren't interested in that. I don't know if I'm phrasing that incorrectly, Michelle, but that was the impression that I got. I don't know. I'm not. I don't think that speaks for every single member of the Prosecuting Attorneys Association. I don't know that speaks for every single person of higher authority with the Michigan State Police, but that was just the general impression from their representatives. What did you think, Michelle?
Yes, I mean, I thought for the most part, people weren't arguing about whether marijuana should or shouldn't be legal. They were, the discussions were centered around how can we look at each of these statutes and see some of the discrepancies between three statutes and how can we fix those so that we can have a better understanding and so that the prosecutors understand how it should be viewed and the defense attorneys understand how it should be viewed. And I think when you have an opportunity to look at the final recommendations that were forwarded to the legislature, I think everybody will see the common ground that we found in a lot of those suggestions that we had.
Yeah, and some of them involve things like the transport of medical marijuana. I mean, there were issues, there were discrepancies between the new 2018 law and the 2008 law. Whether or not you had to have your marijuana in a locked container, what proper possession amounts were under certain circumstances. There were things that, again, there were discrepancies that really had to be worked out. And so our thought was, we don't want to have, this case go where there's any uncertainty or ambiguity, or uncertainty. We didn't want to have one judge in Genesee County decide one thing and one judge in Lake County and one judge in Chippewa County, and then they all come to different decisions. It has to go through the Court of Appeals. Everybody's got to argue about it. Then it goes to the Supreme Court, and it goes back down. I mean, why not just have the statute be as clear as possible and not have courts around the state having to worry about that, and frankly, not have prosecutors around the state charging things because they read the statute a certain way because it was so unclear. So that was really our goal. And we will get you a list so you can see what our recommendations were. And hopefully, even with COVID, I'd like to continue on with the work group and see if we can make a little bit more progress.
I'll just observe that the list of people that you said included in that group didn't include any citizen groups. So I didn't hear that at all. I'll also say the MRTMA has a supremacy clause, so there's no variance between that and the MMFLA because that doesn't have a supremacy clause. So
did you see the group of individuals that we had on there? Do you know who were?
I just heard what you mentioned. You mentioned a couple of prosecuting attorneys associations, SADO, which is the criminal defense, stuff like that.
No, we had marijuana groups on there as well. But anyway, we can get you a list of the individuals that participated so you know who was there. We tried to be as inclusive as possible.
Thank you. Let's move on. Probationers are frequently denied the opportunity to use cannabis while on probation or parole because of a reference to illegal drugs. But in Michigan, cannabis is no longer an illegal drug for adults. What can the Attorney General's office do to help probation assignees or the probation board, parole board, be more proactive in the way that they assign those duties and affect judges' decisions to allow or deny cannabis use while on bond?
Right. So I used to see this all the time. When I practiced both as a prosecutor and as a defense attorney when I'd be in court. And I used to see cases where, maybe somebody would be convicted of, I don't know, it could be a larceny crime. And they'd say, well, you can't have any alcohol and you can't have any marijuana, or you can't have any, prescription medication or what have you. And that person who committed the crime maybe weren't under the influence of any of those things at the time they committed the crime and didn't even have a substance abuse problem. There was no, history of substance abuse by that person. And so it sort of seemed like, well, what's the point of that? Why would you do that? But the thing is that judges have wide discretion in terms of what their probationary terms are, and there were a number of times, and I'm sure you guys are aware of these circumstances, where I'd have a client who had a medical marijuana card, had a condition for which they were legally using medical marijuana. And for them, this is their medicine for whatever type of situation, medical ailment they had. This is a medication that was prescribed by a doctor. And they'd say, well, no marijuana. I'd be like, well, are you going to take away somebody's blood pressure medication or diabetes medication? Why would you take that away? Because it was considered to be different to them. So, it's something that we can, that I can make public statements and urge and argue about. I don't believe that as Attorney General, I have the actual authority to tell judges what they can and can't not decide or terms of probation. I would see things all the time where judges would, be very strict about exactly where a probationer could go, or sometimes even who they could, have associations with, even though we have a right to associate with who we want, but not when you're on probation to somebody. The same way that for a parolee, the state has the ability just to come into your house and they don't need a warrant to do so. So unfortunately, we have fewer rights when we are under the jurisdiction of a criminal court. Even if that doesn't always make sense. I think that there are people like myself that can be out there saying, hey, listen, this is not a proper, you shouldn't automatically, every time somebody gets convicted of a crime that has nothing at all to do with cannabis use, that you automatically say you are not permitted to consume that. But I made that argument all the time as a defense attorney, and unsuccessfly most of the time, unfortunately. I don't know, does anybody else from my team have any suggestions on this? Lisa, what did you see with that, with MDOC with that?
Well, there was a big debate. So I actually was the administrator of the Office of Legal Affairs at the MDOC at the time that everything changed. And the question was, how are we going to handle this with parole, primarily parole, but certainly they handle certain probation cases too. And ultimately it was decided, the terms of parole are that you can't break any law, and it still remains unlawful to use marijuana, cannabis, under federal law. But what they did was change their practice and policy, and they no longer were doing random drug tests for THC. Unless that person's crime was a violent crime associated with marijuana. So, and that was a handful of cases. And so they just really changed their approach to it. And there's new policy language that I'm going to send you a link to the public hearing schedule. I will send you a link to that policy, or send you a copy of the policy as well, that gave direction to parole agents on how they should be treating the use of marijuana. But ultimately, the MDOC recognizes that it is legal in Michigan.
Now, your predecessor, Bill,
so I was just going to say and I'm not going to take, I would love to take credit for that, but I had nothing to do with that, and it happened before I came to the office that decision was made. But that is the kind of thing, though, that when we talk about being able to have a little bit of influence over the departments that we represent, that's an example of something that could be done. Again, wasn't done by me, but where we can have influence in small ways. When you say what can be done, I guess things like that. But in terms of of what the judges in counties all over the state and in district courts and circuit courts all over the state decide to do, all I can do is make public statements. I don't know that I can actually do anything as an attorney general, except for to make, policy related statements that I hope that some judges will listen to.